Thank you. All right, you're Derica Johnson. And Ms. Johnson was previously in court, entered pleas of true in a motion to revoke probation to counts 1 through 4. On probation for aggravated assault causing serious bodily injury, and that was a 6-year deferred probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And there was no agreement, correct? I'd agree. Also, just for everyone, and if we can get copies if you guys need it, I am also reviewing jail incident reports as well. Mr. Rojas, you may proceed.
Judge, as the court knows, this is Ms. Johnson's third motion to revoke. She's been given opportunities in the past to comply with ISF, MRT, and some mental health counseling. She hasn't taken advantage of all those opportunities. She has some CPS cases going on. She's kind of doing double load casework. She's got some CPS cases in Harris County. She's taking some classes through there, and that's
to unravel. The prosecutor lays it out plain. Ms. Johnson wasn't just given probation, she was given multiple lifelines. Drug counseling, parenting classes, probation centers, but instead of taking those chances, she chose a different path. What really strikes me is that even with all those opportunities, she's still asking for mercy, still hoping for the bare minimum. You can feel the court's patience wearing thin, because second chances mean nothing if the person doesn't even try to change.
Johnson is going, I think the option that she would rather do is to ask the court for some mercy and give her the lowest amount of time in prison possible. We would request something in the neighborhood of 2 to 4 years. She, at this point, doesn't feel that she needs a drug treatment, and the ISF program is this thing that, well, she was removed last time because she's pregnant. She's not pregnant right now, so I think this would be the perfect time for her to get ISF and get that help. But she tells me that she doesn't want that. She would just rather go to prison and get this case over with.
Ms. Malfino?
Judge, I concur with Ms. Lopez's updated PSI. It's very thorough and goes through every opportunity this individual has been given by the court. It's a shame she doesn't want the help. Really could help her. I mean, if she was using last time while she was pregnant, she's obviously somebody who has an issue that needs to be addressed. But she doesn't want the help, I guess she shouldn't take up someone else who wants the help spot. And so I think revocation is appropriate with something in at least
breaking. The prosecutor reminds everyone she was using drugs even while pregnant. That alone tells the court she isn't just hurting herself, she's endangering others, even her own child. And then the blunt truth, if she doesn't want the help, she shouldn't take up a spot from someone who does. That statement hits hard, because resources are limited. Judges have to weigh not just one life, but who else could be saved if given that same opportunity.
No, because Ms. Johnson, you have been coming here now way too long and been given every single opportunity to stop talking over me. Because right now, what you're looking at that I can do is give you between 2 and 20 years in prison. And the more you talk over me and are disrespectful, the higher number that's going to get. Do you understand? You have been, I'm not even sure how many times now that you've been in here pregnant, using drugs while you're pregnant, while we're trying to get you help. You have 5 kids that you have no custody of. It's the jail incident reports are ridiculous. And then you want to come in and say, I just want to get this over with. Give me a couple years in prison, which you probably have credit for, which is absolutely not what I'm going to do. Give me just a second. The fact that this is kind of your 4th shot at it makes me wonder what I was thinking the prior 3 times. And really.
The judge is visibly done, frustrated, angry, but also almost sad. Notice how she says, the more you talk over me, the higher your sentence gets. That's not just authority speaking, that's disappointment too. She points to the 5 kids Johnson has lost, the jail reports, the repeated drug use while pregnant. It's raw and emotional because it shows the clash between mercy and accountability. At this stage, it feels like the court's patience has been drained dry.
All right, Ms. Johnson, at this time, I'm going to find that you entered your pleas are true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit for any time that you've been in custody.
Hammer drop. 12 years. You can almost hear the silence in that courtroom after the sentence is read. The judge even admits she wonders what she was thinking the last 3 times she gave her chances. That shows this wasn't easy, but when someone refuses to change, the justice system eventually closes the door. It's a brutal but powerful reminder, every decision adds up, and sooner or later, there are no more life.
Thank you, Your Honor. As the court can see, Mr. De La Rosa is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. De La Rosa would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education. I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well, to help him to develop some skills so that he can make better decisions and get his high school at least minimum.
His lawyer paints a picture of hope, a man struggling, sick, uneducated, but still wanting to be a better father and maybe get his GED. On the surface, it's moving. Everyone loves a redemption story, right? But the unspoken question lingers, is this genuine change, or just words in the face of another conviction? You can sense the defense is doing everything to humanize him, to make the judge see more than just his record.
He has 3 prior felony convictions, 1 for being a felon in possession of a firearm, 1 for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry.
Mr. De La Rosa, you wanted to say something?
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015, that when that conviction was like I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time and I did parole. I did good behavior.
Right. So you should have learned.
This is where reality cuts through. The prosecutor pulls no punches, pointing out 3 felony convictions, gang history, and that this isn't his first firearm offense. Suddenly, the defense's story feels thin compared to the weight of his past. And that's the brutal truth of the courtroom. Your history doesn't just follow you, it speaks louder than anything you say on sentencing day.
Second chance or something.
Well,
I always get like I want to get thrown in prison, come out when I'm 38, something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 20.
Judge at her most blunt. She tells him straight, this isn't anything I'm doing, this is where you've got.
15. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Going to sentence you to a term of 6 years.